What can SITE do for you? The Center for Innovation and Technology offers a business opportunity to engage directly with your market online. We also offer media training workshops, live streaming, documentary production, and events management. For more information, visit our website and social media platforms. Don't forget to like, comment, and share. With SITE, you'll never miss a thing.
A mandate. It's actually the mandate that speaks to the normative principles that guide an institution or a society. We can talk of the NPRC's institutional inventiveness or innovation as based on the national and international laws. For the national laws, we have our NPRC Act, which operationalized the NPRC. And on international laws, we have Paris principles, for example. They speak to national institutions which are supposed to be independent, and the NPRC fits into those national and international laws perfectly. So like I was saying, the NPRC will provide useful insights on the additional mandates of the NPRC. And for us to talk about the NPRC, we have to know that there are 5 pillars that are established by the Constitution to support democracy. And these include the Zimbabwe Electoral Commission, the NPRC, the ZHRC, Zimbabwe Gender Commission, and the Zimbabwe Media Commission. So those 5 institutions have what is called a broad objective that has certain aspects which those 5 pillars or 5 institutions must endeavor to fulfill for the benefit of peace and democracy in our nation. So the Section 233 objectives, and an objective in a constitution binds us all because the Constitution is the mother law of our country, is the supreme law of our country. And when we talk of democracy, we are simply saying we want a situation where a government is by the people, through the people, and for the people. And constitutionalism, we are saying the public citizen who may be occupying the seat of power, be it under the 3 pillars of the state, that is the executive, the judiciary, and the legislature, as well as other tiers of government that are spelled out in Section 5 of the Constitution. We had the speaker speaking about devolution, so we have to talk about tiers of government that will also speak to that. So constitutionalism places the public citizen and the private citizen who does not hold state power under the Constitution. We are saying we want the concept of the limited government that is a servant to the Constitution. And also when we seek to ensure that injustices are remedied, Section 233 is very instructive because it speaks of the term injustices are remedied. So the 5 institutions I spoke about earlier on must ensure that injustices are remedied. And for the injustices that are remedied, we have to identify, do we want to talk of justice in respect of a conflict? Do we want to speak of justice instead in terms of horizontal relations between private and private citizen, or vertical relations between the private citizen and the public citizen who is a state functionary? But key aspects that must run through when we are understanding the NPRC's function is that we must understand 5 major aspects that come out of our Constitution. The first one being sovereignty. And sovereignty has variegated forms in terms of our Constitution. Our preamble speaks of what is called popular or people's sovereignty. It says we, the people of Zimbabwe, have agreed to be bound under certain aspects. Section 1 of our constitution speaks of Zimbabwe as a unitary, democratic, and sovereign republic. It means we can also speak of the sovereignty. So when the NPRC is doing its work, it must also have that aspect running through whatever it will do, because it speaks to those aspects. If we go to section 116, 117, we understand that Parliament is a sovereign in its own right, because it has an oversight role on the NPRC's work. So all these aspects will take us to the supremacy clause. The Constitution is a sovereign in its own right because of section 2 of the Constitution, which says it is the supreme law of the land, and any law, practice, custom that is at variance with the Constitution is inconsistent to the extent of its variance. Then if we talk of our founding values or principles that are in section 3 of the Constitution, we understand that when the NPRC is maybe dealing with a victim who is female, they have also to take cognizance of women's rights, which are part of our founding values. If we are to speak of the rights of the youth, the rights of women, the rights of children, all those aspects will be found in our founding values. And when we talk of our national objectives, we are saying these are part of part 2 of the Constitution, and we are saying all these aspects also provide what we aspire as a nation. And finally, we have our Bill of Rights, which is chapter 4 of the Constitution. Particularly section 44 of the Constitution talks about the duties to respect, promote, protect, and fulfill human rights on the part of the private citizen and the public citizen, including juristic or legal persons such as companies. So we have to observe those 4 duties, which is in Shona we say protection of a duty would be kuchengetedza. Then in Ndebele, what will we say? Protection? Okay. Then promotion, kukurudzira, like he was talking about using our 16 languages, including sign languages. Here we may say, how many of us can sign? Because we now understand that sign language is part of our official languages. So we have to promote. Respect is kuremekedza. I don't know, in the way we say? Respect? Kyonipa. Then fulfill, because that's kisa. What will we say in the way? Thank you, and I think I will get this spelling so that I will use them in future appropriately. So you can go to the next time. So basically, because we're speaking to parliamentarians, Section 16 of the NPRC Act is very important when Parli is interacting with the NPRC, because Parliament may, which is, when we use may, is discretionary, may, through the relevant Parliamentary Portfolio Committee chairperson, cause the Commission in regard to its operations and undertakings and proper to submit such other reports as the Parliament may require. So Parliament has to use the Portfolio Committee to, the Portfolio Committee chairperson to liaise with the NPRC on matters that they want reported. Then in addition to the reports referred to in subsection 1 and 3, the Commission may submit reports to Parliament in terms of section 253 of the Constitution. But the question that each Zimbabwean grapples with is, how far should we go back when we are dealing with peace, reconciliation, and healing? Do we go back to the pre-colonial history, where we use mainly oral tradition? We hear that this tribe was vanquishing that tribe. Do we go to the colonial period, where we have to say, what did the colonialists do? And what also did the liberation fighter do, which may be threatened or moved towards achieving peace? In our post-colonial era, what actually happened? Do we document the early independent period? Like you were saying, you spoke about the first two Endurman wars as well as the Kukraund event. So all these aspects, we then say, what do? We also go to the 1990s. We are talking maybe of economic justice. We go to the early 2000s, then we categorize our conflicts in the manner we want. We go to the present. And all these aspects are just very much important. And in that endeavor to deal with the how far back should we go, we must clearly identify the transitions or changes or political changes that we want. Are they tribal conflicts? Are they colonial issues? Are they political, social, or economic conflicts? And once we do that, we can then move together as a polity. And when we are then dealing with these issues, we then want to say the transitions and the actors. We want to identify who the victims were, who the perpetrators were, who were the affected communities, the affected provinces, as well as the whole committee that is our country. Coming to the NPRC provisions, we know the Constitution as the mother of the law, as the mother law of the land, actually established the NPRC in section 251 and also section 252, which has 10 liberalized functions. And we have the NPRC Act, as I said, which operationalizes the NPRC. And the first aspect which the NPRC deals with is post-conflict. The NPRC does not use, the Constitution does not use the term transitional justice. But it is clear that when we read into the post-conflict aspect, we are saying this is all about transitional and transformative justice. This is justice after a conflict. And our conflicts may be caused by armed conflict or may be caused by serious human rights violations. So the three aspects that we must strive to engage with when understanding the NPRC in post-conflict would be justice. Justice has a lot of colors. It could be transitional, it could be restorative justice, it could be retributive justice. By retributive, we are saying an eye for an eye, tooth for tooth, arm for arm is tit for tat. Then we can also talk of rehabilitative justice, where we are saying let's focus on the perpetrator also to make sure that we integrate, we rehabilitate him back into society. And when we talk of healing and reconciliation, what also comes to us would be the aspect of forgiveness. And as a nation, we understand that we have a lot of areas where we feel that we must find those three aspects under post-conflict aspects. And when the NPRC is also dealing with programming, we understand that the key aspects would be for it to promote national healing and national unity, where we don't use ethnicity, where we don't use tribal linkages, where we don't use political affiliations, but feel that we are one as Zimbabwe. He was speaking about the concept of the Kenya-Rwanda. Rwanda, after genocide, we are told that in 1994, the world was focusing on South Africa because they thought that if the ANC would get independent, perhaps the white community would be vanquished. But we understand that when the international journalists then went to endeavor in Uganda, they could not get to Rwanda. They then got to sell the Rwandan genocide to the outside world. And we understand why the government of Rwanda today is emphasizing on the concept of saying never again. It's not about Vahutu, it's not about Vatutsi. You know what was happening after 1994 genocide. Some saying a certain, maybe the Tutsi must come and occupy Rwanda. Vahutu, send them to another country. Or maybe both Vahutu and Vatutsi must join DRC because they cannot manage their own country. So we are saying unity is very important and cohesion so that we have peaceful resolution of disputes in our country. And there's also the need, one of the functions is the realization of reconciliation. How do we realize reconciliation? The NPRC is enjoined to make sure that there is truth-telling about the past. So because we are speaking with, we are dealing with individuals, communities, provinces, and the nation, it is vital that we understand how each individual and the community and the province wants to tell the truth about the past. In other countries, there is what is called a Truth and Reconciliation Commission. In our country, we have a National Peace and Reconciliation Commission. It's just, to me, about the differences in the name, but the functions are essentially the same. We can talk of a facilitating role. If you facilitate peace, we understand in 2019, the GNU, we had a mediator, but he ended up also taking the role of a facilitator, allowing that the actors can find their own solutions. They can find each other without a very much deep and active involvement of the facilitator. And what we also want, when you are wronged, you want to make amends. He was talking about just saying S-O-R-R and then Y. We used to sing that at kindergarten. So the making of amends is very important so that we speak of what we call the provision of justice, which is also part of that function of the NPRC. The NPRC can also play a vital role in dialoguing. And if we have a constructive dialogue, what the Constitution speaks about is dialogue between political parties. And if political parties engage in constructive dialogue, that will be very healthy for our polity, because we will then have a situation where we can address inter-party differences in an amicable and normative way as envisaged by the Constitution. And once political parties engage, it will be very easy for their political support bases to also come together for the benefit of national reconciliation, national unity, and our societal cohesion as Zimbabweans. And they can also ensure that there's dialogue between communities and dialogue between organizations. The speaker was speaking about doctrinal conflicts. For example, how conflicts in churches are morphing out copically into national problems. So if we have the NPRC identifying, be they Pentecostal, be they, like we used to have the Anglican, we have the Pentecostal in the AFM, we had the Gutaramwari and stuff like that. If we can have the NPRC just dealing with those aspects, we know the church has a very big role to play. And if the NPRC can deal with doctrinal conflict, that would be very important for the development of peace in our country. The Constitution also even talks about dialogue between groups, and the NPRC is enjoined to make sure that different groups, are they social movements, are they youth groups, are they women groups, they work together for the benefit of peace and reconciliation in our country. The other important aspect which the NPRC, in terms of the constitution, can do is what is called alternative dispute resolution. It's not everything that must spill into a court of law. Some of the aspects need viananisi, or they go between those who adopt a middle course approach. It's not everything that needs fights. So you can conciliate. A conciliator can simply try and make sure that parties that are not finding each other do find each other. If there is failure to find each other, he may simply say, I'm issuing a certificate of no settlement. You can go to the other party, which could be maybe the arbitrator who can give an award. An arbitrator would then say, from the presentations you made, it seems you were making a point, so I'm giving this award. And the mediator, sometimes people would prefer meet up, where you include mediation and arbitration together, so that at least maybe you have a clear conclusion, a closure on a certain aspect that affects a community. So the other aspects which the NPRC may also deal with in terms of the constitution include the early detection of areas of potential conflict. We know from our provinces, from our communities, the areas which we call hotspots, be they political, be they social, areas that cause social unrest or economic unrest. And the NPRC can also just deal with matters of promotion of peace and also the programming of issues related to torture and other forms of abuse. Especially for now, we know that we do not have a torture law and we have not ratified the torture convention, and the speaker was speaking about enforced disappearances. If we don't ratify the convention against enforced disappearances, it would be very difficult for us to then say the NPRC must deal with these issues when there is no national law to deal with those aspects, and there's also no international law to also provide guidelines on how the NPRC can deal with issues of torture and enforced disappearances. So the NPRC, because it is allowed to deal with matters incidental to these aspects, it is one institution that can also play a very significant role in ensuring that we also become party and ratify torture and enforced disappearances laws at international level. Do you hear me? Because it seems power saying Section 16 can be used by the relevant portfolio committee to make sure that Parliament has an oversight role on the NPRC's activities, particularly in relation to the operations and activities. But the key aspect is through the responsible minister. The NPRC Act speaks of a Minister of National Healing, Peace and Reconciliation. We seem not to have one at the moment, but the NPRC can also push so that we have that minister as a standalone minister, or the president is, however, allowed in terms of the NPRC Act to appoint a responsible minister to deal with the NPRC operations and activities. So clearly, what the speaker was maybe pointing at was that the NPRC must be doing something that ensure that the Parliament is also made aware of what the NPRC is doing. And Section 16 clearly lays out some of the aspects that Parliament can actually ask the NPRC to provide in their report, and that include the Commission's findings. In whatever they are doing, they can then say, now we haven't yet gotten into the victims to identify who the actual victims were, but we have done some preliminary work, and that preliminary work can be included in the Commission's findings and deliberated in Parliament. We can then have the nature of conflict in existence. The NPRC can go for outreach and then say, we have identified that we have political conflicts, we have economic and social conflicts of this magnitude. They include that in their report to Parliament. They can also include the gender dimensions of prevention, management, and resolution of conflict, because that is clearly laid out in Section 16. We understand that our Constitution, Section 17, speaks about gender in gender equality. And if we then have gender dimensions, reported on gender dimensions of conflict, the NPRC can also work with the Zimbabwe Gender Commission so that we have a detailed report on that aspect which will be given to Parliament, and Parliament will have occasion to ventilate on those aspects. And linked to Section 2 of the Constitution, which is the Supremacy Clause, Section 16 of NPRC Act also talks about the need for the NPRC to identify practices, customs. If you go to the show or any other group under the 16 languages or any other language that is not included as part of the 16 languages, you can then say which custom hinders the achievement of peace or peace building. And the NPRC can report on those aspects. Then there are also laws that hinder peace building. The NPRC is enjoined to include those aspects in its report, including reporting on other laws and admin issues and any other work which the NPRC would feel must be tabled before Parliament so that we have peace building. I must also talk about the complementary mandate of the NPRC. The complementary mandate is based on the broad objective to all independent institutions. That is in Section 233 of the Constitution. Yes, we understand that the NPRC works with the 5 pillars, but we want to have a situation where we know what complementary aspects are they dealing with. For example, the AU, African Union, now has a transitional justice framework. That transitional justice framework says national human rights institutions must do A, B, C. And for our national human rights institution, we have the Zimbabwe Human Rights Commission. But our Constitution clearly says it is the NPRC that must lead in terms of post-conflict justice. But now the AU Transitional Justice Framework as well as the UN speak of the role of human rights commissions. So we want to see the complementary mandate between the ZHRC and NPRC coming clearly to say this is how we want to deal with issues of transitional justice from the perspective of the regional bloc, which is the African Union, and from the perspective of the internationalized or global society, which is under the United Nations framework. And also I know the NPRC indicated that it works with civil society organizations, academia, and researchers. So that complementary aspect must also be augmented by the partnerships that the NPRC has. And these will all these aspects will actually lead to this complementary mandate so that we don't just see the NPRC as an island, but as an institution that works with other institutions in very practical terms. So that as a nation, we can say, if the Zimbabwe Human Rights Commission, for instance, has its own specific mandate to achieve transitional justice, we will simply say, okay, the Constitution says before 2009, the Zimbabwe Human Rights Commission cannot try to deal with aspects that happened before 2009. if it is dealing with issues after 2009, it might then indicate those aspects, but obviously preventing situations where we will see the Zimbabwe Human Rights Commission doing the NPRC work, or the NPRC work ending up doing the Zimbabwe Human Rights Commission's work. So essentially, what I can just in summary say is that the crucial aspects for the NPRC is that it must be post-conflict, which deals with the transitional issues. By transitional, we can say from 1979 to 1980, we had a compromise constitution. That was the Lancaster House constitution. In 2013, we had a transition, we had a homegrown constitution. In 2009, we had the government of national unity. We had the GPA speaking about the need for inclusion and participation of the general populace, which participated in the constitution making. And after participating in the constitution making, we had our own homegrown constitution. In 2017, we have another transition, which was under the Operation Restore Legacy. We want to understand how we can then deal with all those transitions from a contextualized and constitutional perspective. And when we talk of transformative, we are saying the end result must be the focus on reform of the institution concerned, so that justice is not just just understood in a transitional manner, but in a manner that will equip people who benefit from a particular institution. And the NPRC will then deal with the procedural aspect and all the other recommendations which I have indicated. So let me just also indicate that from my reading of the mandates, 5 key aspects also come out. That is national healing, national unity, national cohesion, peaceful resolution of disputes, and the realization of national reconciliation through truth-telling and facilitating of the making of amends and provision of justice. So with that, I will say, Domini Vobiscamo, peace be to you all, and to use our own version of peace begins with me, you, and all of us. And with